Showing on this episode of Law Weekly, a chat with the president of the Nigerian Bar Association on the planned State of the Nation dialogue. It tells us why this is necessary and what the bar seeks to achieve with it. Also showing on the program, early reactions trailing the judgment of the Osun State Governorship Election Petitions Tribunal, which nullified the election of Governor Adebola Adeleke of the People's Democratic Party, plus a recap of some of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. The president of the Nigerian Bar Association, Yakubu Mekiao SAN, has convened the NBA State of the Nation dialogue, which will hold on Monday, January the 30th. At that event, presidential candidates in the 2023 elections will speak to the bar on the three main areas of security, economy, and administration of justice. On Tuesday the 31st, the president will deliver a State of the Nation address, which will articulate the position of the bar on these three issues. Now, why is the NBA putting this together and what is the benefit to Nigerians? My colleague Ella Obaje Daniels spoke with the president of the bar to get his take.
The Nigerian Bar Association at this time decided to put together what it described as the NBA National Dialogue. And I would answer your question using two statements. The first by Sir Christopher Sapara Williams, who said that the legal practitioner lives for the direction of his people and for the advancement of the cause of his country. That clearly underscores the primary responsibility of every member of the legal profession. Because as a member of the legal profession, you are called to a privileged position to provide leadership to your people. Everything about Nigeria, for instance, is a function of the law. It is by the Constitution of the Federal Republic of Nigeria that we have a country today. It is also by the laws that draw their lives from the Constitution that would have all the institutions that operate the process of governance of the people in this country. And only the lawyers have had the privilege of being trained in that business of the law. So whatever you do as a nation and the things that you do in the process of dealing with the people within that entity, which is Nigeria now, we're talking about, is a function of the law. So the lawyer understands it better. And for instance, just to give you a little more light to it, ignorance of the law is no excuse. It means whether you read law, whether you know it or not, whether you are literate or not. If the law says you should do something a particular way and you fail to do it, the fact that you do not know or you are ignorant of that law does not make your burden or your responsibility any less. How much more for the lawyer that was trained and he knows it? So the national dialogue is intended to set the tone for the nation in furtherance of that leadership position that we are privileged to occupy. And how do I mean? We have three thematic areas that would inform the discussion at the national dialogue. Number one, the issue of security. Security is something that concerns everyone in this country today. If there is one thing that we are sure to have eluded us in this country, is security. Number two, economy. And security has a direct impact on the economy. I mean, what you do, absent security, really cannot provide the sort of economic growth that you expect in the nation. And then again, the administration of justice. Administration of justice because it is important for us to have justice in the nation, absent which you cannot have a nation, so to speak, because there is going to be chaos. And a statement was made by Usman Danfodio, which I found very profound. He said that a people can exist without religion, and you know Nigerians are quite religious, but that the people cannot exist without justice. And we call ourselves ministers in the temple of justice. So what we do, the service that we deliver to the people, the responsibility that we have to the people of this country to dispense justice to the people is intricately connected with the existence of this nation. So what we are trying to do, by the special grace of God, with the national dialogue, is to bring back the Nigerian Bar Association, to bring back the entire legal profession from its place of abdication to the place where we begin to demonstrate consciousness of the privileged position that we occupy vis-a-vis the people and begin to provide leadership. Let the people know that by reason of this privilege that we occupy, that privileged position that we have, we are living for the direction of the people. We are also living for the advancement of the cause of the nation. So that is why we have come together as an ESCO under my leadership to have this national dialogue. We set the tone for the nation. We invite presidential candidates. We set the benchmark for them from the point of view of the Nigerian Bar Association. We listen to them also, talk to us about what they intend to do when they assume office. And any one of them who wins the election, we are going to hold him accountable by what he has come to commit to us on behalf of the people of this country. So it becomes a basis for us to call you, knock on your door, whoever wins the election, to say, well, we had an engagement with you, and you now have a contract with the people of Nigeria, the social contract. They've elected you into office. These are the things that you said in these three broad areas. What have you done? What plans do you have? And these are the things you said to us. So it becomes a basis upon which we can hold them accountable for the stewardship that Nigerians would entrust to any one of them that would eventually win the election. That essentially is the reason for convening the national dialogue by the Nigerian Bar Association.
So let's talk specifically about the administration of justice, which is one of the three core areas of the dialogue. By putting it on the front burner, is it an admission that the country is not where it ought to be?
Well, let me answer this in a general sense, and I won't go into specifics because that would mean having the dialogue ahead of the 30th of January. I am tempted to apologize to Nigerians on behalf of the entire legal community in this country. And you see, I can do this because, number one, God permitted me to be alive today. God made it possible for me to be a lawyer. If you listen to my story or you read my story, you know I have no business being in law. I was a student of veterinary medicine when someone told me that I've been admitted to read law. Fast forward today, I'm the president of the Nigerian Bar Association. If God permits it to happen, and there is no authority anywhere except the one that God has permitted. So I stand in position to do what I just did. Apologize to Nigerians because the legal profession has abdicated its responsibility. And it is largely the reason why we are where we are today. And so, yes, we are not where we are supposed to be. And I believe that if the legal profession, if the members of the legal profession have come to the realization of who they are and acted with the understanding of that identity and lived for the direction of the people of this country and for the advancement for the cause of this nation, we wouldn't have been where we are today. We wouldn't. And let me maybe give a little bit of context. I just quoted what Sir Christopher Sapara Williams said. And that has to do with an understanding of the primary call of every lawyer. How many of our lawyers today, and it includes me, senior lawyers, those of us that are privileged to be senior lawyers, have made statements like this or have lived this sort of life? We also have a senior advocate who demonstrated an understanding of this sort of life. Late Chimeze, the senior advocate that started the Legal Aid Council, he sold his properties because he saw that the indigent people didn't have representation, and he began to render legal service to them free of charge, pro bono. That is what is responsible for the emergence of the Legal Aid Council. It started by the work of one individual who had an understanding of that primary responsibility. But what do we have today? With due respect to all of our colleagues, we are reputed more for the amount of money we charge for the cases that we do. Hardly would you hear any one of us being reputed for standing for his people, giving direction for his people, and actually standing for the advancement of the cause of this nation. So that is where we are, and I believe in a general sense that it's because the legal profession has abdicated. So we owe Nigerians an apology, and we must begin to work our way back from that point of abdication to the place of responsibility. And that is why we are doing this. We won't just allow anybody to come and take responsibility for the governance of the people. We would hold you accountable. We are the ones that the people are looking at. They are looking up to us for leadership. And that also brings me to the place of how we have conducted ourselves. Because for us to be able to provide that leadership, the people must have confidence in us. And that calls for responsibility in the area of our professional conduct. We have to be professional in things that we do. We have to be ethical in our own conduct. We cannot afford to conduct ourselves in a manner that would erode the confidence of the public in the profession. And that is why the administration of the Nigerian Bar Association, under my leadership, we are very, very strong about professional conduct.
Can you do an assessment or evaluate where the administration of justice is presently?
We are not doing badly, given the resources that is available for the administration of justice, but we have lots of concerns. I mean, for instance, if you look at the police, because it's a complete chain. You look at the police service, you look at the prison service, you look at the courts, the welfare of the judges and justices, you look at the staff, what is the manpower available. Look at the infrastructure that the judges and justices have at their disposal to do their work, their constitutional responsibility. And you would agree with me that with the little that is available to them, they are doing their best to deliver justice to the people of this country. We are not where we should be, but we are certainly not at that place where we had always been. We've moved ahead, but we are not where we ought to be. We came on board with the understanding that there has to be a deliberate investment in the administration of justice, and particularly with the judiciary. You have to be deliberate about the welfare of the judges and justices. Many of them, if you see the volume of the work they do, it takes a great toll on their health. We don't even have packages for them, welfare packages that cater for their health, given the kind of workload that they have to deal with. And so we decided that the first thing we have to do is to begin to speak to government about the need to review the salaries and allowances of judges and justices in this country. What did we do? We set up a committee immediately, and at every forum, we spoke about it. We set up a committee for that judicial salaries and allowances review, and because of the importance of that subject, I chaired that committee. We had consultations at different levels of the courts in this country. We had also consulted other judiciaries across the world and looked at what they do for their judges and justices. And we came up with a report. And incidentally, that report was submitted to the Revenue Mobilization and Fiscal Commission. And it is our hope that in addition to submitting that report, we would have an opportunity of sitting down with the Revenue Mobilization and Fiscal Commission to look at those reports together with other stakeholders and see what we have proposed. We are prepared to justify all our recommendations in that report. So that is what we have done from the standpoint of the Nigerian Bar Association.
So I would like you to react to the alleged endorsement of the PDP governorship candidate for Akwa Ibom State by the NBA State Chapter of the association.
Well, that's assuming it is true. assuming it is true. That is despicable. It is disgusting. Every adjective that you can use to condemn that, and I condemn it in all its sense and ramification, because the Nigerian Bar Association, actually when I saw it, I thought they are talking about a national basketball association somewhere, until I saw a reference of the Nigerian Bar Association. That cannot be the Nigerian Bar Association that I know and that I heard today by the special grace of God. Nigerian Bar Association is not partisan. Nigerian Bar Association remains neutral. The responsibilities of the Nigerian Bar Association, amongst others, is to the promotion of the rule of law, and you cannot do that if you are partisan. I mean, they have no business endorsing any candidate for any position whatsoever. And so I have also called the chairman to say that, look, if you people did this, I'm issuing you an instruction, because he said that was not what happened. That's what I said, why I said if that actually happened. He said that was not what happened. There was an attempt to do that, but that did not happen. I said, well, you have to issue a statement immediately to say that that did not happen, because that cannot be a representation of what the Nigerian Bar Association stands for.
Welcome back. Let's now look at the much talked about judgment of the Osun State Governorship Election Petitions Tribunal, which nullified the election of Governor Ademola Adeleke of the People's Democratic Party, and the early reactions from lawyers in the case.
The Governorship Election Petitions Tribunal, sitting in Osogbo, the capital of Osun State, has nullified the election of Governor Ademola Adeleke of the People's Democratic Party. In the judgment, read by the chairman of the three-man panel, Justice Sese Akume, but dissented to by one of the three members of the tribunal, says the July 16, 2022 governorship election was conducted in non-compliance with the Electoral Act and violates the principle of one man, one vote. Admitting that overvoting took place at many polling units as filed by the petitioner, the tribunal applied the mathematics of deduction of the questionable votes, leaving the APC candidate with a higher vote of 314,931 and the PDP candidate with 290,266. The tribunal consequently directed the Independent National Electoral Commission to withdraw the certificate of return issued to Ademola Adeleke and return Gboyega Oyetola as the validly elected governor of Osun State.
All praises to Almighty Allah for what is done for us today. It's a very solid, industrious judgment, and they delivered it on time as they promised. We are grateful for that.
Would you want to say anything on the other? It's a tripod standing on two legs for now.
Well, the point you had, this is, if you like, this is the first round we have won. It is up to the other side to decide what they want to do, whether they will just accept this now and go home, or they will go upstairs. Whatever the decision, we are there, and God is there.
A member of the tribunal cited inconsistencies in submissions surrounding the use of BVAS or its abuse, saying there is positive evidence to sustain the petitioner's case, as the BVAS report relied on by the petitioner was not even taken in evidence.
What is an issue is the BVAS mention. This tribunal took a view that it is the BVAS report issued after the report says it was, their documents say it was on the 17th. The report says it's on the 27th. And that BVAS report, which is a report which is stated, the INEC stated clearly at the tribunal, had not been synchronized as at that point. And it affected 1,750 units. The petitioner simply just took 750, 749, and in the tribunal and moved on to reduce to 744. And the tribunal, the chairman agrees that that is the only document.
If it has not been synchronized, who gave it to the...
No, you apply and you have 14 days under Section 74 of the Evidence Act, and we issued what we have as at that time. And you go to Section 64.
Synchronized.
Yes, as Section 64 says, authorizes INEC to update the results continuously. So results is as the server gets the data. Anyway, what the point I'm making is that there was the Beavers report, which they are relying on, which is the first one I talked about. There was a Beavers report tendered by INEC on the dated 22nd of August. And there was the physical figures on the Beavers machine, CTC, made certified by INEC based on the orders of the tribunal. The tribunal said, now go and check the Beavers machines and give us the scores in them. That is exhibit RWC. And the Beavers machines, 976 of them, were also brought to the tribunal, and the parties looked at them. So what the law is, and will be maintained until any time, is that it is the Beavers machine, which the facts are still in the Beavers machine in the custody of the tribunal. The Beavers machine, it is the figures in the Beavers machine that ought to be transmitted. So the transmission is a secondary process.
Meanwhile, Governor Adeleke has described the judgment of the Governorship Tribunal as a miscarriage of justice, vowing to challenge the ruling at the Court of Appeal.
The beauty of the hierarchical system we have in Nigeria, you see, you have cost for appeal. We're going to the Court of Appeal, and then we get to the Supreme Court, which is the apex court. You will see that what happened here today was most unusual, in the sense that you had a judgment by the chairman, you had a judgment by one. The third did not even say a word. She neither said she supported nor she did not. So it's 1-1. But we say that in the Court of Appeal.
And just before we go, let's quickly do a recap of some of the other top stories from the courtrooms.
We begin with the reports that the Supreme Court has upheld the Court of Appeal judgment which awarded the All Progressives Congress APC Abia Central Senatorial District ticket to Sam Onuigbo. The Supreme Court delivered 2 appeal judgments against Emeka Atuma in favor of Onuigbo. Affirming the judgment of the Court of Appeal Owerri Division, Justice Koram Agim said that Onuigbo is the legal and rightful candidate of the APC for Abia Central Senatorial District. Away from the Supreme Court, the Presidential Campaign Council of the People's Democratic Party has commenced a legal process to disqualify the presidential candidate of the All Progressives Congress, Senator Bola Ahmed Tinubu, from contesting the 2023 presidential election. The PDP Campaign Council approached the court to ask for Tinubu's disqualification over allegations bordering on conviction for trafficking in narcotics in the United States. The PDP is also asking the court to compel the Independent National Electoral Commission INEC to immediately delist Bola Tinubu as presidential candidate of the APC or any other political party. At the Federal High Court, Abuja, Justice Binta Nyako has declined to nullify the candidacy of the Gombe State Governor Mohammed Inuwa Yahaya. Justice Nyako dismissed an allegation that the governor submitted forged documents to the Independent National Electoral Commission in aid of his qualification. The suit was brought before the court by the opposition People's Democratic Party and 2 of its chieftains in the state, Mohammed Jibrin Barde and Timothy Danlele. They insisted that the governor was inconsistent in the dispositions he made on oath and therefore ought to be disqualified from participating in the governorship election slated for March 11. They equally asked the court to restrain the third defendant from parading himself as the governorship candidate of the APC in the state. But the counsel to the APC and the governor, Mr. Marshall Abubakar, challenged the competence of the suit even as they persuaded the court to dismiss it. In her decision on the matter, Justice Nyako upheld the defendant's preliminary objection and struck out the suit for want of competence. In Lagos, the husband and sister of late lawyer Bolanle Rahim have testified before a state high court sitting at the Tafawa Balewa Square in the trial of an assistant superintendent of police, ASP Drambi Vandi, charged with the Christmas Day killing. The husband, Benga, who testified as the third prosecution witness, told Justice Ibironke Harrison that the late Bolanle was rushed to 3 different hospitals before she finally passed on. When being led in evidence by the Attorney General of Lagos, Senior Advocate of Nigeria, Moyosoro Onigbanjo, the witness admitted that though he did not see the defendant shoot his wife, his sister-in-law Titi did. He also testified that he witnessed the defendant point a gun at his sister-in-law after she rushed down from their car to confront him. The witness went on to narrate how he rushed to 3 different hospitals, Budo, Doran and Granville, where his wife was eventually confirmed dead, ostensibly because help did not come in good time. After the husband's testimony, the 4th prosecution witness, Titilayo Enema, the younger sister to the late Bolanle, took to the witness box to narrate her account of what she witnessed. She identified the defendant as the officer who shot her sister and also pointed a gun at her. After their testimonies, Justice Ibironke Harrison then adjourned till February the 1st and 2nd for continuation of trial.
That's the program for today. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shoyele. Thank you for watching and see you next week.